Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. And my guest today is attorney Timothy Bupp. Welcome, Tim.
Tom, I'm excited to be here.
Well, thank you. Tim is an attorney with CGA Law Firm in York, and he handles mainly estate planning. And the subject today is inheritance tax, specifically the Pennsylvania inheritance tax. And Tim, that gets me to my first question with respect to inheritance tax. Pennsylvania has what we call an inheritance tax. The federal government has something called an estate tax.
Two entirely different things.
Okay, can you explain why?
I can. Well, like I said, I'm excited to be here. I often say I'm excited about tax law, and usually I'm kidding when I say that. But I am excited about particularly Pennsylvania inheritance tax because recently there have been some changes to the tax law which are potentially very advantageous for clients. And so finally I have something interesting to talk to you about.
Okay, and we're going to get to that. We're going to get to that later in this program, the exciting changes. But before we do that, let's give the foundation.
Right. Federal estate tax was the tax that we always planned around because it was a much more onerous tax than Pennsylvania inheritance tax. Federal inheritance taxes, as recently as 15 years ago when I was in law school, was so burdensome that every estate that had more than $300,000, it's actually $375,000 in it, was subject to this tax, and the tax rate was 55%.
Well, I can beat that, Tim, because when I was in law school 15 years prior to that, it was $175,000 for the federal estate tax.
Well, we're both showing our age, but those days are long gone because around the year 2001, when George W. Bush became president, we did dramatic changes to that law, and the exemption amount for federal estate tax is much higher now. Now we don't talk about dealing with federal estate tax planning until a married couple has more than $10 million because the exemption is $5.35 million. So that kind of tax planning is not nearly as prevalent as it used to be because that tax only affects less than 0.2% of all estates.
So basically
nationwide.
The federal estate tax is for people who are very wealthy.
That's right. Pennsylvania inheritance tax is entirely another thing.
Okay.
Here in Pennsylvania, Pennsylvania inheritance tax, which is the other death tax we worry about, affects nearly everybody, and it starts with the first dollar. There's no exemption amount. It's very all-inclusive. Just about everything that you can think of is subject to Pennsylvania inheritance tax. Everything that passes by reason of my death to beneficiaries, people that inherit it, either have to pay that tax or my estate has to deal with that tax.
Okay, and what is that what is the amount of that tax?
The rate of the Pennsylvania inheritance tax depends upon who the beneficiary is, which is also a very unusual thing. The tax between spouses is zero. When I pass away, anything that passes to my spouse, it's technically subject to the tax, but the tax rate is zero. Husband and wife are treated as a taxable unit together.
And it does not matter whether it was jointly owned or not. Am I correct?
Well, we're going to talk about jointly owned assets, but for now, everything that passes to a spouse, zero tax. Anything that passes to lineal descendants, children, grandchildren, or to parents or grandparents, the rate is 4.5%. As far as tax rates go, that's a pretty small rate. There's also a special rate for siblings. Taxes on assets that pass to a sibling is taxed at 12%, and the tax for everybody else is 15%. 15% is the standard rate for Pennsylvania inheritance
So if I were
tax.
to write a will and leave something to a friend who I was not related to, the tax would be 12%, but if I left something to my children, it would only be 4.5%.
You were real close.
Okay.
15% for unrelated parties.
15%
15 is the standard
I'm sorry.
rate.
12% for a brother or sister.
12 is a sibling.
What about a niece or nephew?
Niece and nephew, that's not a sibling. That's 15% just like everybody else.
Okay. But children, grandchildren, great-grandchildren, 4.5%.
That's right.
Okay. As well as to your parents.
Right.
Okay.
Now, you had mentioned joint assets.
Right.
Right? Anything that passes by reason of my death is taxed, whether it passes under my will or whether we're talking about a joint asset, like real estate that two people own jointly, husband and wife, for example, or bank accounts that are in the bank where there are two owners. Anything that passes by reason of my death gets taxed. Right? So if I have a joint account with my children, the Department of Revenue is going to treat that as if on my death, half of it was mine and half of it was my child's. And so they're going to say that half of it is subject to tax. And the tax rate would be 4.5% on half of it. And that's the case whether or not I put all of the money into that account or whether my children put all the money into the account. If the parent didn't put all the money into the account, and we can prove that they didn't by showing where it came from, then we might be able to persuade the department to accept less tax. But in general, it's 50-50. You have to pay tax on half of it.
Okay. So, and I've seen this happen to people, and it's sad, but a parent puts an account in joint name with a child, and then later on the child dies. The parent then has to pay tax on 50% of the money.
Which was all theirs to start with.
Which was theirs to start with. Exactly right.
Yeah, it happens. People do all kinds of planning to try to avoid this tax. If they do it in a vacuum without good counsel, they're really taking their chances as far as what might happen.
Right. So, and there are some planning techniques to deal with the Pennsylvania inheritance tax.
They are, but they're very limited. Maybe the first thing to look at is, even though I say this tax is pretty all-inclusive, there are some assets which are not subject to Pennsylvania inheritance tax, which is very few.
Can you go over those?
I can. Life insurance proceeds is the big one. Life insurance in Pennsylvania is not taxed. So if I leave $1 million to my child, they're going to pay tax. But if I have $1 million life insurance policy on myself, and those proceeds pass to my child, they're going to go inheritance tax free. There's also some limited exemption for inheritance tax for assets that are retirement assets. If I'm not old enough to take that money out without a penalty, then when I die, if it passes to my beneficiaries, they don't have to pay inheritance tax on that.
So somebody who is 50 years old, if they were to die and they had money in a 401k or an IRA, that could pass to their children?
Those proceeds would pass to whomever the beneficiary is without any inheritance tax on it.
And that's an important point that you make, is it passing to the beneficiary. That doesn't necessarily need to be spelled out in a will, am I correct?
That's correct. Pennsylvania inheritance tax is all-inclusive. Covers the things that pass in my will to my beneficiaries, or those non-probate assets like life insurance policies or retirement funds, 501
and that's an important point also that most people need to understand is that there are certain things called a probate asset and certain things called a non-probate asset. Okay, and for example, something that's jointly titled with the right of survivorship. If I own a building joint with someone other than my spouse, let's say it's my brother. Mm-hmm. I own a building jointly with my brother with the right of survivorship. If I die and my will says I leave everything to my children, my brother still gets that property because the deed to that property said, to the survivor. He'd still have to pay inheritance tax on 50%, am I correct?
That's correct. You'd make a fine attorney or a fine estate attorney in your second career after domestic time.
Okay.
Yeah. Non-probate, probate assets, it doesn't matter. Pennsylvania inheritance tax is very inclusive. It's not just for the things that pass under your will, it's for anything that passes by reason of my death.
So let's say, that we have a will in place and there are certain assets that are going to be transferred. What happened? How is the tax paid?
Okay. You had talked about planning, and I'll answer your question by saying there's two places where we can do good planning to try to, let's not say avoid inheritance tax, but control it. The first is in your will, right? Not everybody has a will, but it's truly beneficial to people to have a good will that has a good tax clause in that's going to describe exactly where the inheritance tax obligation comes from. Because when I pass away, those assets pass to my beneficiaries, and it depends on my will as far as who's going to be paying that tax. Most tax clauses say that the tax should be paid from the residue of my estate, the final portion of my estate, which usually is passing to my children. But you need to be careful to describe carefully where your assets are going and think about who's going to have to pay that tax obligation.
Right, to give an example, if I have a house that I want to gift to one child, mm-hmm. and I want to give the residue of my estate, which has greater value than the house, to another child,
then you'd better be careful in the way that your will is described, or your one child may end up paying the inheritance tax on the house that he's not receiving because the other child is receiving.
Okay. Or I could say that it comes out of the residue of the estate because the child receiving the house might not have the resources to pay the tax.
Absolutely.
Because they'd have to mortgage the house in order to pay the tax, and for whatever reason may not be able to qualify to do that. You don't know.
And that's very unfortunate, and it does happen at times.
I've seen that happen where somebody gets an asset because the intent of the decedent was that they would have that house in particular.
Right.
And then they have to pay the inheritance tax on it, and they don't have any other source of funds to do that, to pay that tax. So they have to either sell the house or mortgage it to pay the tax. But that can be avoided if there was other money in the estate and proper estate planning was done.
Good planning is usually worth every penny, can avoid problems like that.
Oh.
The second sort of line of defense for good control of inheritance taxes, when I actually pass away and there is an estate, right? To pay the tax, that tax is usually paid to the Department of Revenue, and it's paid using a special tax return. It's called a Rev 1500. It's not the kind of tax return that typically an accountant prepares. It's considered the practice of law, and an attorney usually prepares that return, right? It's a little complicated return. There are a lot of deductions that you can take that will qualify, that will make that tax burden less, but a lot of people don't know that. And it's very common, Tom, that there are non-probate assets like a joint account that's in the bank, and when I pass away, that money goes to my child, and suddenly my child is going to receive a letter from the Department of Revenue saying, we've been notified by the bank that there's an account that you received by reason of your father's death. Half of it is taxable, and the tax rate is 15%. Please send us a check.
All right. And you told me before that the tax rate is 4.5% for a child.
For lineal descendants. But the Department of Revenue doesn't take time to try and figure out if that joint beneficiary is a child or a brother, or they just send out a bill that says 15%. A lot of people say, well, I don't want to go to my lawyer and get them involved. That's going to cost me money. I'll just pay the tax. You pay the tax without guidance, you take your chances, right?
So basically, if the letter doesn't tell you it's only 4.5% if you're a child, it says the tax is 15%, and the burden then is on you as the beneficiary to go in and say, wait a minute, I'm a lineal descendant, I get a deduction in the tax to 4.5%.
Absolutely. Not only that, but just as most tax returns, there's a lot of deductions that you can take on a tax return related to funeral costs or the costs of administration or bank costs. You can deduct those costs and again pay less tax. And on top of that, Pennsylvania inheritance tax is due within 9 months of my death. So within 9 months, that tax has to be paid. However, if you pay the tax within 3 months, within 90 days of my death, you get a discount of 5% of the tax that's owed. You can't get 5% in a bank anywhere, so we usually try and hit that. But most folks won't know that unless they get good guidance to deal with the inheritance tax issues when a death occurs.
And basically there's a form that gets completed, the inheritance tax form, where you would put down what the assets are, who's receiving it, what the tax rate is, and any deductions before you have to pay the tax. And as I'm saying that, I notice we're almost out of time for the first half of this program. We'll be back in a few moments. My guest is Timothy Bupp. We're talking about the Pennsylvania inheritance tax. This is Legal Lines. Welcome back to Legal Lines. My guest today is attorney Tim Bupp from CGA Law Firm. We're talking about the Pennsylvania inheritance tax. And in the first segment of the show, Tim said there's some exciting new news.
Finally, I get to talk about exciting things.
Now you get to talk about the exciting new news in the world of Pennsylvania inheritance tax.
I've been describing inheritance tax as exciting for years, and I was always kidding with people. It's always been very static. As long as I can remember, there have been very few changes in the Pennsylvania inheritance tax law, but that has all changed in the last 2 years. In 2012 and in 2013, in successive years, there were new acts put forth and approved by the legislature which have made dramatic changes to the way that family-owned business assets are taxed for inheritance tax purposes here in Pennsylvania. 2 new exemptions, which is great if you qualify for those kind of exemptions, if you have the particular kind of assets which can pass free of tax.
Now, you mentioned family-owned businesses. What's the other exemption?
Well, the other one is family farm business assets. That's the one that was adopted first. Act 85 of 2012 was a real change for family farm businesses. Family farms have always been treated differently as assets in Pennsylvania. Agriculture is so important to Pennsylvania. It's our #1 industry, and there's always been an effort to try and conserve farm ground and to preserve family farms. We saw that very early on in the tax laws because farm ground in the past was always taxed for inheritance tax purposes at its what they call its clean and green value, which is its farm value, not its highest and best value. There was always additional discounts for that tax if a farm property was in preservation, in the preservation program, such that it could never be developed. Then the family of the decedent that inherited that property only paid half of its clean and green value. But now the legislature took an additional step. Farm ground that's in a family farm business passes without any inheritance tax, free of inheritance tax, as long as certain requirements are met.
Okay, what are those requirements?
The requirements are pretty easy. It has to pass to particular family members, and the definition for these purposes is pretty broad. It can include siblings, nieces, nephews, lineal descendants, parents. As long as it's pretty much anybody you'd consider your family, as long as they receive that property, there's a potential for it to be exempt from inheritance tax. But that's not all. It's got to stay in a family farm business for at least 7 years. The family needs to keep operating that farm, keep producing at least $2,000 in income, farm income from it, which is pretty moderate. And as long as they meet those requirements, there's no inheritance tax that has to be paid on it.
So how is it monitored that the farm continues to operate for those 7 years?
Well, the Department of Revenue is going to generate a form, and they're going to send it out to those beneficiaries who receive it, and every year they're going to have the obligation of confirming that the farm remains in a farm business. And if they don't, then they'll have to pay the tax back, and they'll have to pay some interest and maybe some penalty on it as well. But it's a real benefit for family farm businesses. Now, I'll ask you a question, Tom. Why in the world would this happen? I've heard a lot of attorneys at a lot of seminars say, why are we treating these assets differently? I have a house, I have money in the bank, I have to pay inheritance tax on it when I die. Why would we treat family farms different?
I'm just not used to people asking me the questions on this program, but I would believe you already answered it when you said that farmland has always had a special place in the law, and that even when farmland was taxed, there were special tax laws that dealt with it. Sure. I think this was just taking it one step further in the goal of protecting family-owned farms.
You're exactly correct. Those guys in the legislature aren't dumb. They know that farming is big business. Jobs, income, all those things get taxed, generate our tax base. The last thing that they want to do is kill the goose that's laying the golden eggs. They want it to keep laying those eggs. They want those family businesses to keep employing people and to stay in business. And there was a lot of concern that family farm businesses were being driven out of the business by the fact that they had to sell farm ground to cover this onerous inheritance tax bill. No, I don't know if that's true or not. The inheritance tax rates for families are pretty moderate, as we said, 4.5%.
Although one thing that I find interesting is this applies to more than just lineal descendants.
That's correct.
Which, as we talked in the first half, the tax rate is different. A niece and a nephew, for example, would have a 15% tax rate, but as opposed to a child, which would have a 4.5% tax rate. But if you leave the family farm to a niece or a nephew, it's still exempt completely, so there's zero tax.
That's absolutely correct, and that's a higher tax rate. And I think that underscores how important the legislature feels that agriculture and family farm businesses are to our tax base and to Pennsylvania.
Okay, and so it's monitored, as you said, for 7 years, and if for whatever reason they decide to sell the farm outside the family,
then they've got to pay that tax back. However, there's even better news for not nieces and nephews, but for lineal descendants. Because the Department of Revenue came back and clarified the law, and here's what they said. Particular assets, farm ground, farm commodities that pass to lineal descendants, not to your sibling, not to your niece and nephew, but to lineal descendants, are not only exempt if they keep it in business for 7 years, they're exempt outright. So if a farmer passes away and leaves that active business to his child, the ground, the cows, the crops, the corn in the bin, all of these are entirely exempt from inheritance tax. Really remarkable thing. We're talking about situations where we're tens of thousands of dollars in tax, maybe hundreds of thousands. Dramatic difference.
So the goal there is basically to protect farmland and protect the family farm.
You've got it.
All right. You said that there's another exemption that was added.
The law benefiting family farm businesses was so popular that the same legislators sponsored legislation the next year which addressed not only family farm businesses, but family businesses in general. A family-owned business that qualifies, and we'll talk about the requirements, can also be exempt entirely from Pennsylvania inheritance tax as long as it passes to lineal descendants and as long as they keep it in business for another 7 years, just like the previous law.
So if I was asked, why would the legislature do that? I believe my answer should be to keep business here in Pennsylvania. Small businesses, family-owned businesses are the backbone of our economy. So we don't want to destroy them by having the family give up the business because they have to pay the tax.
You described that so well, I want to vote for you for the legislature.
Well, I'm not running for anything, but I assume that's the policy.
Exactly. Now, the requirements for the family business exemption is a little bit more strict than the previous exemption. First of all, cousins, right? Siblings, they're out. Now we're talking about lineal descendants.
So
right?
Just the children of the business owner.
Spouses of the decedent and lineal descendants only benefit from this. And they still have that obligation of 7 years of keeping it in business, right? But there's also an unusual wrinkle in that law, Tom. Nowhere in it does it talk about those lineal descendants' spouses. So I can leave that business to my son and have it be exempt. But if part of it goes to my daughter, I've got a problem.
Daughter-in-law.
Daughter-in-law, I'm sorry. Yeah, my daughter, my son's spouse. Spouses are out. Why is that? I don't have a good answer for you. I really believe it's an oversight in the law, but it's one that we are going to have to plan around until there's a little bit more clarity. So if I pass away and my family business passes to my son and my daughter-in-law, they better get ready to pay some tax. Whereas if it would just go to the son, there's no tax. Now, good lawyering will plan around that, right? With a will, or maybe after I've passed away, there are still some things that could be done with disclaimers to get around that. But that's first and foremost a real underline, a reason to emphasize good planning in this kind of exemption.
But basically, the way the law works is if someone owns a business and they have children, they can leave the business to the children, and the children do not have to pay any inheritance tax, so long as the children run the business for 7 years. So I assume that there's some type of monitoring.
Same kind of monitoring program that we said before. The Department of Revenue is going to send them a form, and they're going to have to vouch for the fact that the business is remaining in the family. There's also a lot of restrictions on exactly what kind of family business can be exempted for this. The limitations are that the business can't have a net book value of more than $5 million. If you got a $6 million business, you've got a problem, right? Also, it can't have more than 50 employees. More than 50 employees, again, 51 employees, again, you've got a problem. right? So the exemptions are very narrowly prescribed in the law. But again, Tom, that doesn't mean that good planning won't get us around that. We have had discussions where a larger business might be broken into two businesses, because you can have as many businesses as you want to be exempt from the tax as long as you meet the qualifications.
That might also be a good idea for other reasons, such as you have 2 or more children and you want to leave them each separate businesses.
Plus, you don't ever want to put all your eggs in one basket. But there's more of a reason for that kind of planning than ever before with the exemption from this kind of tax. Something else that's very interesting about this law is that while in many ways it's more narrow than that family farm law we were talking about, in at least one way it is more generous. If we're talking about net book value, that might include all of the equipment, all of the inventory, maybe assets like accounts receivable, cash on hand. You might be talking about a lot broader assets than we were talking about under the family farm law. There, while commodities, right, and crops in the field were exempt, equipment was not. And if you've been down in my end of the country, you know that farmers have a lot of equipment. Those combines can be several $100,000. Those are the kind of things that should be exempt from inheritance tax if you want that business to succeed.
So that's the business of the farm, which would qualify under the business exemption?
These are new laws and we are still getting used to them. But you hit the nail right on the head. In my opinion, there's no reason why that family business exemption shouldn't apply to that family farm business. It certainly should. I think under the exemption for the second law, you can exempt the equipment, which otherwise wouldn't be exempt under the first law.
So, but the way you phrase that means that this has not yet been challenged or determined by the state?
Well, you know what it's like, Tom, when you get 2 lawyers in the same room, you won't get the same answer from both of them. These are brand new laws and the Department of Revenue is still dealing with them. There haven't been too many opportunities for us to see case law that's going to develop these particular laws. But there's every reason to be hopeful that with good planning, we can really take advantage of this to the benefit of our clients.
And one of the other things I wanted to ask, let's say, and you see this happen, let's say the father owns a business and he has a son and a nephew who are operating the business.
Right.
Now, the nephew would not qualify for the exemption, the son would.
That is 100% correct. And
what happens then?
That would be a real problem, right? The law says that when I die as the business owner, every owner of that business has to be a qualified beneficiary, a lineal descendant. So if my daughter-in-law owns 1 share of stock, I've got a problem.
I see.
If my cousin is in that business, or if over the years I've given some stock to my manager, the key man of the business.
We're going to run out of time in a minute, but I think what you're getting at is it has to be 100% to the children.
Right.
So if the daughter-in-law owns 1%,
we've got
it's
a problem.
all subject to tax?
Absolutely.
I did not realize that. I thought the 1% would be, but I can't go any further because we ran out of time. My guest today was Tim Bupp. The topic was Pennsylvania inheritance tax. My name is Tom O'Shea. This is Legal Lines. Thank you for joining us.